Welcome to your key discovery point. I am Brett Burney from Nextpoint, joined by Doug Austin of eDiscovery today. Doug, you covered a case this week that came out of Nebraska just a few weeks ago. February 21st was when the opinion was filed. And it's a post that highlights, or a case opinion that highlights, once again, the importance of not just putting a legal hold in place, but also following that legal hold and overseeing that legal hold. As in this case specifically, if you have an old hard drive that might contain some relevant data, you don't throw that in the trash. That's not a good place for it.
No, it's not. And yeah, this was an interesting case, and the ruling might be a little bit of a head scratcher, as our colleague Tom O'Connor would say. But I also think there's a couple of lessons to be learned here. So, in essence, just to kind of set the facts here real quickly, basically a case involving misappropriation of proprietary data. The case was filed in August of 2021. And the one of the defendants, basically a president of one of the companies being, who was the defendant, disposed his hard drive from his laptop basically about a month or so later. He claimed that the laptop hard drive malfunctioned, basically because it was BitLocker encrypted and he couldn't get out of it. He couldn't get through to it. So he basically claimed he took it to Best Buy for service, ultimately replaced the laptop or the drive in the laptop and so forth. Ultimately, the plaintiff didn't find out about the hard drive failure and replacement until October 22, over a year later. So, as you can imagine, they started pursuing that, and they had a series of hearings with the court. The person was ordered to submit to one deposition, and then that led to a second deposition, and then even a reconvening of that a second deposition, and what have you. And ultimately, the plaintiff filed motion for sanctions. Now, a couple of things here. The court, even though the defendant had disposed of the hard drive, and it seemed like there were inconsistencies, and he kind of attributed failing memory, as part of why he couldn't recall some of the details. The court did say that, or did rule that he was, or did basically denied the plaintiff's request for an adverse inference sanction, which is kind of interesting because, in this case, they said they didn't really prove intent to deprive other than, the failing of memory, and considerations there. But one of the things the plaintiff did was they also filed for Rule 37E1 sanctions, including the fact that they were prejudiced by the loss of the data and so forth. And the court did grant some sanctions there. One of the things, and you're actually on, well, yeah, on this, I'm sorry, no, go back up. I was, to that one.
Yes.
It's one of the things that the court said in this case is while Ogle discounts these changes to failing of human memory, he is at the same time adamant about what was not on the laptop, any relevant information. The court is not convinced you can have it both ways. So you can't say I don't remember, but I'm sure there's not data on the the laptop drive. So the court awarded reasonable attorney's fees and costs, which are not going to be inconsequential because there were, like say, several hearings, depositions.
For several years.
They ordered a deposition from the Best Buy representative that worked with them. So the defendant's going to have to pay for the plaintiff's costs for all these hearings and what have you, as well as their own costs that they had to incur going through all this. So it was not inconsequential. So I think a couple of things in terms of lessons learned. If you're a requesting party, we've seen cases where parties swing for the fences and go for an adverse inference sanction or a case dismissal.
right.
and don't get anything. But sometimes the Rule 37E1 sanctions are a good fallback. If you don't get the really serious sanction, at least you get something for the conduct. So I think that's a good lesson learned from a requesting party standpoint. From a producing party standpoint, you might look at this case and go, "Hey, I can freely just discard data, and I may not, get serious sanctions." But
Right.
we've seen cases that have just likely gone the other way for similar circumstances.
Definitely.
Plus, there just because you may not get an adverse inference sanction or worse, you still could get some serious sanctions. So again, it's important to have that policy in place to preserve the data, to communicate with your counsel. Basically, counsel said that they had set up a litigation hold from April 2021, even before the case was filed. But obviously, this hard drive was not ultimately included in that, and that was a mistake that cost them.
Yeah, I would almost think I'm sort of paraphrasing it here, but it's like the court found that Mr. Ogle here was, I guess, negligent in the way that they were not holding that, but that didn't amount to an action in bad faith, right? Where
Right.
it was enough to say we're going to make sure that you're going to pay the attorney's fees, but it's not so much to show that there was bad faith here that we're going to go for an adverse jury instruction. Which, to your point, right? They swung for the fences there, but at least they got something for their
Right.
time
Well, they
as
swung for
opposed
the
to the
fences,
full.
but they also, when two strikes in the count, they also, tried to hit a solid single, and they at least
Right.
got that, because one of the things that you can never tell, and I've covered enough cases, is that, the what one court considers bad faith, another court may
Yeah.
not. So you can't.
Right. Right.
There's not very many guarantees.
And there's a
So
lot of
that's
leeway
why.
here, right? I mean, in
Right.
fact, you link to, of course, as always, which is really good, Kelly Twigger's eDiscovery assistant, where if you read through here, the judges the judge goes through some of this here, that there's a lot of leeway on the judges and what they can award. And to your point, it's a little,
Right.
dicey sometimes because it's like, well, we need some hard and fast rules in some cases, but there is a lot of
Right.
leeway there. And even one of the other factors, I don't think that you addressed it, but I saw it in the case here where they were talking about if we can't get information from one location, could we get information from other locations, such as email
Right.
typically is, we can get it from the server if the hard drive isn't there. But in this case, there was some specific software and CAD drawings and things that may, there was enough evidence to show that it possibly was just on that laptop. And that's another one of the several factors that the judge has to go through here. But wow, a good case for some good lessons in there for sure. And then, so I'll just point out another blog post that we have at Nextpoint where we talk about. I thought about this when I was reading your post, Doug. Don't let self-collection spiral into self-destruction. In some cases, if you just leave it up to the individuals, we have found time and time again, they get a little nervous, they get a little scared, and they're going to do what they can to self-preservation a little bit. But unfortunately, that doesn't mean self-preservation in the sense of self-collection
Right.
from a litigation side, and that can be a little dicey on there. So that's your key discovery point today. If you know that there could be some relevant information on a hard drive, even if you have to get it replaced, you might want to still make sure that you're preserving that adequately. Thanks for joining us today. Thanks, Doug.
All right. Thanks, Brett, and bye, everybody.